Your grandmother left you her house. She left it to you specifically by name with the address written out in full in a will she had made 7 years before she died and reviewed twice since. She had never changed it, not once. 3 weeks after she died, her second husband filed a legal document claiming that house now belonged to his children instead. The document had her signature on it. It had a notary stamp. It was dated October 11th. Your grandmother was admitted to hospital at 9:45 a.m. on October 11th and did not leave until October 13th. The notary stamp said 2:30 in the afternoon. Somebody had made a mistake, the kind you cannot explain away. This is what happened next. On January 14th, a judge ruled that the codicil was fraudulent. Gerald Marsh, his son Todd, and his daughter Renee faced criminal charges for will forgery and probate fraud. The house at 4112 Maple Grove Drive was legally yours. It had been legally yours from the day Evelyn died. It had taken 18 months to make a court confirm it, and it had taken 3 separate pieces of evidence, each of which would have been sufficient on its own to construct a case that was ultimately inescapable. Your grandmother's name was Evelyn Ruth Harwood. She was born in 1938 in a town 3 hours north of the city, the youngest of 4 children, and she had moved south at 19 to study teaching and had stayed because the city suited her in the way that some cities suit some people, not because of what it offers on paper, but because of the rhythm of it, the specific light at certain times of year, the way the downtown blocks of it connected to one another in a grid that she had eventually memorized the way you memorize a piece of music. She had taught elementary school for 31 years. She had retired with a reputation for patience and a classroom full of children every year who came back to visit long after they had moved on. She had been married once before Gerald to your grandfather Raymond for 44 years, and the quality of that marriage was something you grew up inside of rather than observe from outside, the way you grow up inside a climate rather than study climate rather than studying it. She had lived at 412 Maple Grove Drive for 31 years. The house was a double-story brick structure in a tree-lined neighborhood that had been middle-class in the 1970s and had become quietly valuable as the neighborhood aged and held. Raymond had bought it with money from his pension and from Evelyn's savings, and they had painted every room once together on a single long weekend in their first year there, Evelyn standing on a stepladder with paint in her hair, which is a story she told at least once a year for the rest of her life. The house had a kitchen that faced east, which meant good morning light, and a windowsill that was permanently in sun for the first 3 hours of every morning. On that windowsill, Evelyn kept the blue ceramic rooster she had bought at a market in Lisbon in 1987 on the only international trip she and Raymond had taken together. The rooster was hand-painted, imprecise, clearly made by someone who had been making them for a long time and had stopped trying to make them perfect. Evelyn loved it specifically because of that imprecision. She said it was the most honest thing she owned. You had visited that house every summer for the first 18 years of your life and regularly since. You knew the sound of the third step from the bottom. You knew that the kitchen light took 11 seconds to warm to full brightness in winter and 5 in summer. You knew where Evelyn kept the good scissors and where she kept the adequate scissors, and that the distinction between these two categories was something she took seriously. You knew that she read every night before sleeping, always 2 books at once, fiction and non-fiction alternating chapters, a practice she had maintained for 40 years, and that she described as keeping both halves of the brain in conversation. You knew these things because you had been present for them, because Evelyn was the kind of person who allowed presence, who made a house available to the people she loved in a way that settled into you over years and decades. Raymond died in 2007 after a short illness. He was 71, Evelyn was 69. She had known him for 51 years, been married to him for 44, and the 4 years after his death were years she navigated with a composure that you recognized as real rather than performed because you were close enough to her to know the difference. She grieved. She said so directly in the Sunday evening phone calls that had been a fixture of your life for as long as you could remember. Every Sunday at 7:00 p.m. Evelyn called, and if something was difficult, she said it was difficult, and then you talked about something else too, because she understood that grief required company and company required things other than grief. She was 80 years old when Gerald Marsh appeared in her life, and she was by every measure available to you, fully herself. She drove her own car. She kept her own garden. She made her own decisions. She had been making her own decisions for 80 years and showed no signs of stopping. Gerald Marsh had been widowed 4 years before he met Evelyn at a community seniors recreational event at the local recreation center in 2018. He was 73. He was pleasant in the way that people with a purpose are pleasant comprehensively and without variation, which is different from the way people who are simply pleasant are pleasant, which is selectively and dependent on circumstance. He was attentive to Evelyn in public, solicitous, helpful with small practical things. He drove her to appointments, he carried things, he remembered preferences. The people in Evelyn's social circle responded to this positively. He seemed kind, he seemed genuinely fond of her. The reading that was available was a good one. You did not take that reading entirely. Not because you had evidence against it, not yet, but because something in the quality of Gerald's attention was different from the quality of attention that comes from genuine feeling. Genuine feeling is inconsistent. It varies with mood and energy and context. Gerald's attention to Evelyn was consistent in a way that suggested it was managed rather than felt. You noticed this and filed it and said nothing because you had nothing to say that would not have sounded like jealousy or overprotection, and because Evelyn was 80 years old and perfectly capable of making her own decisions and would have been right to say so. They married in the autumn of 2019. Evelyn was 81. The wedding was small, immediate family and a few longtime friends. Gerald's 2 adult children attended, his son Todd, who was 47 at the time and who worked in property management, and his daughter Renee, who was 44 and who was a bookkeeper. You met both of them that day. Todd was pleasant in the same managed way his father was pleasant. Renee was quieter, watchful in a way that you attributed at the time to shyness and later reattributed to something else entirely. The wedding was brief and the reception was at Evelyn's house, the same house at 412 Maple Grove, and you remember standing in the kitchen of it with a glass of wine and looking at the ceramic rooster on the windowsill and feeling something you could not name at the time. Not grief, not fear, something between the two. Gerald moved into 412 Maple Grove Drive in March 2019, 5 months after the wedding. What followed over the next 4 years was a pattern that has a name in social work and elder protection literature, though you did not know that name until you were already inside it. The pattern is called financial and social isolation, and it works through incremental change rather than dramatic action, through each individual step appearing reasonable and unremarkable while the cumulative trajectory moves steadily in one direction. The book club meetings move from monthly to occasional. Evelyn mentioned this in one of the Sunday calls, saying the scheduling had become complicated. She said this without complaint. The Sunday calls began to run shorter, sometimes 15 minutes, where they had always been 30 or 40. Gerald was in the background of some of them, not speaking, just present. There was a call in the second year of the marriage that you ended and then sat with for 10 minutes afterward, trying to identify what was different about it. You concluded that Evelyn was choosing her words more carefully than she used to. Not lying, just containing. Not saying things she might normally have said. You told yourself this was a normal adjustment in a new domestic situation. You told yourself this more than once because it needed telling more than once. Evelyn's financial accounts changed. She mentioned this in passing during a call in 2020, that she and Gerald had consolidated some accounts for convenience, which was not an unusual thing for married couples to do and which you received as normal at the time. Over the following year and a half, all 3 of her main accounts had Gerald listed as a joint holder. You learned this after her death when you were trying to understand the estate picture. The consolidation had happened in stages, small steps at intervals long enough that each one seemed like an independent practical decision rather than part of a sequence. Her GP changed in 2021. Gerald suggested a clinic closer to the pharmacy he preferred. Evelyn said this was more convenient. Her new GP was 15 minutes further from 412 Maple Grove than her previous GP, who had known Evelyn for 9 years and whom Evelyn had trusted specifically because of that length of relationship. Her estate planning lawyer changed in the same year. Carol Finney had prepared Evelyn's original will in 2015 and had been her solicitor for 20 years. After 2021, Evelyn's legal work was handled by a new lawyer introduced through someone in Gerald's network, whose firm specialized in estate planning and whose biography on his firm's website did not mention probate litigation because it did not need to. You raised this change with Evelyn in a phone call in November 2021. You said you had heard she had changed solicitors and asked if she was happy with the new arrangement. Evelyn said the new lawyer was very efficient. She said this with a quality that you recognized as the quality of someone reporting a fact rather than expressing a feeling. You asked whether she had reviewed her will recently. She said everything was in order. You said you were sure it was, and then you moved the conversation somewhere else because you had nothing specific to say and because pressing a point you could not articulate would have felt like an accusation, and Evelyn did not deserve to be accused of anything. She was 83 years old and entitled to manage her own life. What she was not entitled to was having someone manage it for her without her full understanding of what was being managed. You did not know, at that point, the extent to which that was already happening. Evelyn died on the morning of October 15, 2022. She was 84. She had a cardiac event at home during the night and was not responsive when Gerald found her. She was transported by ambulance to the hospital, but did not regain consciousness and died in the early hours of the morning of October 15th. Gerald called you at 6:43 a.m. You drove 4 hours to reach the city and arrived at the house in the afternoon of October 15th to find Gerald there already at the kitchen table with his son Todd, who had arrived that morning. The ceramic rooster was on the windowsill. The house still smelled like Evelyn. You sat in it for a long time that afternoon and you did not speak much, and that is all you will say about that part of this. Carol Finney, who had prepared Evelyn's original will, reached out to you 5 days after the death. Carol explained that while she was no longer Evelyn's active solicitor, she retained the original will in her records and felt obligated to contact you given the provisions it contained. The will was clear. The house at 412 Maple Grove Drive was left to you specifically and explicitly. Evelyn had not hedged this bequest. She had not framed it as a percentage share or a conditional gift. She had named you your full legal name and the property its full municipal address and stated that the bequest was unconditional and absolute. The financial accounts were to be divided equally between you and your mother. The personal property was itemized with named recipients for specific items. The blue ceramic rooster was listed by name and attributed to you. Evelyn had always known exactly what she wanted. The will was the written form of a decision she had made 7 years earlier and reviewed twice since, both times confirming it unchanged. 3 weeks after Evelyn's death, Gerald Marsh's lawyer filed a document. It was called a codicil. Codicil is a legally recognized amendment or supplement to an existing will, and when properly executed it can modify or replace provisions in the original document. The codicil that David Peel filed on behalf of Gerald Marsh was dated October 11, 2022, 4 days before Evelyn's death. It purported to replace the bequest of 412 Maple Grove Drive from you to Gerald's children, Todd and Renee Marsh, in equal shares. It bore a signature in Evelyn's name. It bore a notary certification stamp. It appeared, on its face, to be a legitimate legal document. David Peel submitted it to the probate court with a cover letter that described it as a final amendment made by the deceased in the days before her death, reflecting her final wishes regarding the primary asset of her estate. You read the document on a Tuesday morning in early November. You had requested copies of all estate documents through Carol Finney, who had received the codicil from the court registrar and forwarded it to you. You read it at your kitchen table with a coffee that you stopped drinking partway through. Your first response to reading it was not the response you would have predicted. It was not panic. It was not panic. It was not grief. It was a very specific sense of wrongness, the way you feel when a sentence is grammatically correct but still contains a word that does not belong. Something in the document was not right in a way you could feel before you could name. You called your mother. You called your mother's sister. You called Evelyn's neighbor of 22 years, a woman named Patricia Caldwell, who had been at the book club and who had known Evelyn as well as anyone outside the immediate family. Patricia said, when you described the codicil, something that you have returned to many times since. That doesn't sound like Evelyn. She always knew exactly what she wanted. She wouldn't change her will in the middle of a cardiac week and leave it to people she barely knew. Patricia was not a lawyer. She was not a lawyer. She was not an estate specialist. She was a woman who had known Evelyn Harwood for 22 years, and her observation was the most accurate summary of the situation you had heard. At this point, you had the codicil and no way to fight it yet. You hired a DSOB. The referral came from a colleague whose family had been through a contested estate several years earlier. He specialized in probate and estate fraud, which is a narrower and more specific practice area than general estate law, and her professional record on her firm's website was described entirely through case outcomes rather than testimonials, which suggested a kind of professional confidence that you found reassuring. Your first meeting was a 2-hour consultation. The D's went through the codicil methodically, examining it the way a specialist examines a document when they are reading it against a mental template of what valid documents in this category look and feel like. She noted the notary stamp. She noted the date. She noted the signature. She said nothing evaluative during this reading, which told you she was reserving her assessment until she had asked the question she needed to ask. She asked 2 questions. The first, was Evelyn hospitalized or medically incapacitated at any point during October 2022? The second, did you have any correspondence or documentation from Evelyn dated close to October 11th? You said you would check the hospital records. She said she would help you obtain them through the formal medical records request process. You said you had letters and cards from Evelyn going back years and that the most recent written communication was a birthday card sent in late September, about 2 weeks before October 11th. Dee said, "Get me that card. The signature on it is going to matter." The medical records request took 3 weeks to process. Hospital records are subject to privacy protections and the release process has specific requirements. As a family member listed in Evelyn's medical contacts and with the proper estate authorization documents, you were entitled to request records related to her care. The records arrived by certified mail on a Wednesday morning in January. You opened the envelope at your kitchen table and sat with what you were reading for approximately 20 minutes before you called a Deezy's. Evelyn Harwood had been admitted to Riverside General Hospital on October 11, 2022. The admission timestamp was 9:45 in the morning. She had undergone a cardiac procedure that afternoon, after which she was placed under post-procedural observation and remained hospitalized overnight. She was discharged on October 13th at 11:20 in the morning. The codicil bore a notary stamp with a certification time of 2:30 p.m. on October 11th. At 2:30 p.m. on October 11th, Evelyn Harwood was in a hospital room at Riverside General, approximately 12 kilometers from the notary's office address printed on the certification stamp. She had not appeared before a notary at 2:30 p.m. on October 11th. She could not have. The D's received the records that afternoon. Her voice on the phone was controlled in the way that professional voices are controlled when they contain something significant. She said, "This is the date problem. If the notary stamp is fraudulent, the certification is fraudulent, and if the certification is fraudulent, the codicil has no legal standing. We need to verify the notary." She began the process of requesting the notary's appointment records for October 11th through a formal procedural request. What the records showed when they arrived was that no appointment with a client named Evelyn Harwood had been recorded at the notary's office on October 11th or on October 12th or on October 13th while she was hospitalized. No appointment had been recorded for any client matching her description or her address. The notary stamp on the codicil was either fraudulently applied or had been affixed to a document without any actual notarial proceeding having taken place. The second thread was the handwriting. You had sent the birthday card to Adiz as requested, along with 3 other pieces of correspondence you had received from Evelyn in 2022 and 2 signed documents from Carol Finney's records, the original will and a bank authorization letter from 2021. Adiz had referred these, along with the codicil, to a forensic document examiner named Dr. Sylvia Brandt. Dr. Brandt had been practicing forensic document examination for 23 years and had testified as an expert witness in more than 230 proceedings. Her professional methodology was based on comparative analysis of signature exemplars across multiple known documents, looking at a range of characteristics, letter formation, pen pressure distribution, the natural tremor patterns present in aging handwriting, the proportional relationships between specific letters, and the spatial dynamics of how a particular writer moves from one character to the next. Dr. Brandt compared the signature on the codicil against 6 known exemplars of Evelyn's genuine signature. The exemplars spanned from 2015 through September 2022, a range of 7 years, which meant any changes in Evelyn's handwriting due to aging or health were visible across the exemplar set and could be accounted for in the comparison. The report Dr. Brandt produced was 31 pages long. It was precise and technically formal for 29 of those pages, and then at the end it contained a plain language summary that stated her conclusion without qualification. The 14 specific inconsistencies she identified between the codicil signature and the genuine exemplars included the following. The letter pressure was heavier overall on the codicil signature in a way inconsistent with Evelyn's natural baseline, suggesting the writer was pressing more deliberately than a natural signature requires. The natural rightward drift in the uppercase E that appeared consistently across all 6 genuine exemplars, a characteristic tremor pattern specific to Evelyn's late-life handwriting, was absent from the codicil signature. The proportional relationship between the capital letters and the lowercase body of the signature in the codicil was inconsistent with the proportional relationships in all 6 exemplars. The letter R in Harwood showed a formation style in the codicil that appeared in none of the genuine exemplars. 14 points of inconsistency across a 31-page technical report. The plain language summary at the end of the document said, "The signature appearing on the codicil document is not consistent with the genuine signature of Evelyn Harwood and is, in my professional opinion, a forgery." Days received the report on a Thursday morning. She called you and read you the summary paragraph over the phone. Then she said, "We have the hospitalization, we have the handwriting, we need one more layer if we can get it, because the standard for criminal referral is higher than the standard for civil probate challenge, and I want to give the DA everything they need." The third layer was the digital metadata. IDs had been pursuing the original electronic file of the codicil through the probate discovery process. David Peel's office had produced only a printed copy in the first instance. The D's challenged this and made a formal request for the native digital file under the applicable discovery rules. The request moved slowly, as procedural requests through opposing counsel tend to do, but it eventually produced the file. The file was in a standard word processing format. Its digital metadata embedded in the file's properties showed a creation date of October 29, 2022, 14 days after Evelyn's death. The document that claimed to be Evelyn's final amendment to her will, signed by her on October 11th while she was alive and 4 days before she died, had been created on a computer on October 29th, 2 weeks after her death. It did not exist while Evelyn was alive. The metadata also identified the device on which the file had been created. The device identifier matched a computer registered to Todd Marsh, Joel's son, the same Todd who had arrived at 412 Maple Grove on the morning of October 15th. 3 pieces of evidence. Hospital records establishing Evelyn's physical impossibility of signing the document on October 11th. Forensic handwriting analysis establishing that the signature on the document was not Evelyn's. Digital metadata establishing that the document was created 2 weeks after Evelyn was already dead on a device belonging to one of the named beneficiaries. D's filed a formal fraud allegation with the probate court. The court referred the matter to the district attorney's office. The DA's office opened a criminal investigation. Gerald Marsh had been charged, the ruling was in, and before I close this story, David Peel was separately referred to the state bar for a disciplinary inquiry regarding his role in filing a document that was demonstrably fraudulent on its face. Whether Peel was an active participant in the fraud or was himself deceived by his clients was a matter that the bar inquiry addressed separately from the criminal proceedings. The criminal proceedings against Gerald, Todd, and Renee took the shape that criminal proceedings take when the evidence is clear and the defendants have limited capacity to argue against it, which is to say they move toward resolution slowly but without apparent uncertainty about where they were heading. The civil probate matter resolved first. On January 14th, the probate judge ruled the codicil void and fraudulent. The original will was reinstated in full. The house at 4112 Maple Grove Drive was declared to belong to you under the terms of the original will. You were in the courtroom. You had been in the courtroom for the procedural hearings that led to this point, too many of them to count, over 18 months, sitting in the public gallery with Adizes beside you while the legal process moved at the pace legal process move at the pace legal processes move. On January 14th, you heard the judge read the decision in the measured, factual language of a judicial ruling, and the phrase that stayed with you was not the most dramatic one, but the plainest. The original testamentary instrument reflects the clear and documented intent of the deceased, and that intent is restored. Gerald Marsh and his children had created a document after Evelyn's death, put her name on it, and submitted it to a court of law in order to take her house. They had used a fraudulent notary stamp and a forged signature. The document had never been valid. Evelyn had not signed it. She had not been present for it. She had been in a hospital bed when it was supposedly notarized, and the document itself had not existed until 2 weeks after she died. Gerald Marsh was charged with will forgery and probate fraud in the spring. Todd Marsh was charged with forgery and identity fraud related to the document's digital creation. Renee Harlow was charged as a co-conspirator. The criminal proceedings moved through the courts at the pace criminal proceedings move. David Peel's bar inquiry concluded the following year. On the morning of January 14th, the civil matter closed and the house was yours. You walked through the front door of 412 Maple Grove Drive on a January afternoon with the keys that Carol Finney had been holding for you since October 2022, keys you had not used in 18 months while the courts resolved what Evelyn had already decided 7 years earlier. The house was cold. It had been minimally heated through the estate administration period, just enough to protect the structure. The rooms were as they had been. Gerald's possessions had been removed through the legal process earlier. The furniture that Evelyn had chosen was still there. You went to the kitchen first. You went to the kitchen window first. The blue ceramic rooster from Lisbon was there. It had been cataloged as estate property during the proceedings and had remained in the house under a legal inventory. Evelyn had listed it in her will by name. She had assigned it to you. It was imprecise and hand-painted and entirely itself, and it had been sitting in the winter morning light of that kitchen window for as long as you had been alive. You stood there for a while with your coat still on, not thinking about the 18 months or the legal process or the 3 pieces of evidence. Just there in the kitchen that smelled like Evelyn in the light she had always put things in. Prisha Caldwell had said Evelyn always knew exactly what she wanted. She had been right about that. Evelyn had known it in 2015 when she first made the will. She had known it in 2017 when she reviewed it and confirmed it unchanged. She had known it every Sunday evening at 7:02 p.m. for the last 14 years of her life. She had known it the week before the wedding when she said, "I know exactly what I'm doing. Make sure you remember I said that." The forgery had tried to overwrite that knowledge. What it had underestimated was how precisely Evelyn's intention had been documented and how clearly it stood up when someone with the right expertise was asked to read it carefully. The ceramic rooster was on the windowsill. That was where Evelyn had always meant for it to be. It had taken 18 months and 3 pieces of evidence and a forensic document examiner and hospital records and a digital metadata report and a probate court ruling and a criminal investigation to confirm what Evelyn had written down 7 years earlier without ambiguity. Some things should be simple. Sometimes they are not. Sometimes you have to fight for what was already yours, and the fighting is not the point. The house is the point. The will is the point. The will is the point. The intent of the person who made it is the point. Everything else is just what happened between her decision and the law catching up with it.